Good afternoon, everyone. This is Joseph Shepard at Wolfsdorf Rosenthal LLP. Thank you for signing up and attending today's webinar topic, L-1, H-1B, and PERM compliance for human resources. I am joined by fellow presenter Jerry. Why don't you say hi and introduce yourself?
Hi everybody, this is Gergana Tzekova. I am an attorney with Wolfsdorf Rosenthal, and I will be presenting regarding the PERM and compliance with.
And thank you, Jerry, for filling in. Mr. Rosenthal has an unavailability due to losing his voice. So it was very kind of Jerry to step in and do this. She's very experienced and very knowledgeable. So let's just jump right in. This slide gives you a general overview of what topics we'll be talking about. This is different from last year's presentation in a few ways, primarily because as of this summer, the FDNS has also begun doing site visits for L1A petitions. So we'll be talking about that primarily in the first section. We'll discuss the LCA attestations as they relate to the public disclosure file for H-1B compliance issues. And then for the last third, we'll be discussing PERM compliance and the documents and considerations employers need to maintain. Well, first of all, what is the FDNS? What are these site visits all about? The stated purpose is to, quote-unquote, foster a culture of compliance within the U.S. immigration system. That is at least what they are saying as of now. So far, this was recently reported as of October, but the numbers were as recent as May 2014. Up to that point, since the program's inception, FDNS has completed 75,000 site inspections. This is the random site visit program done to, ensure everything is matching up with what was put in and as an exhibit to H-1B petitions. Most of these have actually been verified. So more often than not, much more often than not, the site inspections go swimmingly and the site inspector's report is given back to USCIS as verified. Of course, there are times when it's not, and many horror stories have arisen among different HR professionals and immigration attorneys likewise. And so what we're going to discuss today is how to ensure you're not one of the not verifieds. Like I said previously, L1A petitions have also now become subject to the random site visits. But I think, one kind of common myth about the FDNS site inspections is there something wrong with our company? Are we on some kind of blacklist that we're getting these site inspections? The answer is, well, first, not necessarily, but no. The FDNS site inspection program is really a randomly generated. Targets are randomly assigned by zip code for post-adjudication site visits. They don't disclose the exact percentage of which H-1B and L-1A petitions are selected, but they are, it is a random selection just to ensure compliance with the program. That does go hand in hand with their stated purpose, which is to foster the, climate of compliance in the immigration system. So what this really means for employers, that's what we're going to discuss. Let's talk about what goes into it. What gives them the right, so to speak, to, come into your place of business in the middle of a work day and walk around and take photos and talk to people? Well, the USCIS takes the position that when you sign the Form I-129 petition, you are actually giving your consent to be investigated both electronically, meaning, public websites, etc., but also in person, the physical workspace. This also includes, they're looking at, social media. Is your company on LinkedIn? Is the beneficiary of the H-1B or L-1A petition on LinkedIn, is that matching up with what was put in the petition about their job? All these things are considerations, so be aware that these are, in fact going to be looked at by someone in the government. Making sure that someone's, perhaps profile on the company website is consistent with the information in the petition and vice versa. This is because, they don't want someone to say on an H-1B, this is a, for example, computer software engineer, but maybe the LCA was done as something, completely different. It's all about making sure that everything's consistent and on the up and up. While the site inspector is going through these things, and I'll get into the mechanics in a minute, just realize, though, that if, while they're doing the inspection, they can't verify some of the information, or there's no document, or perhaps the company contact or the beneficiary is not there that day, they'll follow up via email with some more requests. If they're, usually it's a pretty quick email if the person is unavailable, or maybe the business is closed. But they can also do follow-up emails, even up to a couple months later. But one of the more important things that we've seen, site inspectors are giving very short time frames within which you can respond. So be aware that even if the person who's the company contact is not there that day, or the beneficiary is not there that day, have a plan in place so that perhaps there's a backup person at the company who is also knowledgeable, knows where everything is, and can facilitate giving copies of documents to the site inspector if requested that day, just so that you don't have to deal with this response. Nonetheless, if you do get an email like this from a FDNS site inspector, send it to your corporate immigration counsel as soon as possible so that they can help you discern exactly what is required to be submitted. Some of these requests after the fact, especially for the L-1A petitions we've seen, have in fact asked for documentation that perhaps is either not included in that particular L-1A, or that is completely irrelevant to the case. Like I said, you want to be able to create an action plan. Who's the chain of command? Who's the first person that they'll be interacting with? If it's the security reception, whoever's at the front of the office, the first contact, let them know about the potential for these site visits. Also, you don't want to assume necessarily that anyone who just says they're from immigration or the government is in fact a site inspector. Ask for ID, make a photocopy of their ID, business card, badge, etc. Find out if they are in fact FDNS, or are they Department of Labor? Are they wage and hour? Are they Department of Justice? Are they ICE? Those are all different types of site inspections, and some of them those are not necessarily random or applicable here. So it's important to know ahead of time who you're dealing with, and to let your corporate immigration counsel know as well. FDNS does not always wait for counsel during a site visit. They, sometimes are accommodating if you want to have the attorney on speakerphone, for example, during any interviews with beneficiary or company contact, but not all the time. Nonetheless, it's important to think about having someone, whoever it is, write down everything that is asked during an interview. Have someone maybe be with them as the quote-unquote host during the site visit. It's not in anyone's best interest to have someone wandering around unaccompanied around the business premise. They do take the position that they are allowed to walk around, ask questions to people, and take photographs of workstations, etc. At the same time, though, you want to make sure that you're documenting exactly who they're talking to, what they're asking, and what they're taking photos of. You don't want to get into a situation where they're alleging something A, and you have no record of it otherwise to confirm, verify, deny, etc. One thing that the person who's in charge of this action plan for FDNS would be to periodically review the H-1B and L-1A compliance files. The biggest part of a compliance file for FDNS site visits on either the H-1B or L-1A context is having a complete copy of the petition as filed with USCIS on site. Now, this is a non-public document, but nonetheless, it is a document that you should have on hand and review periodically just to make sure, has so-and-so gotten a raise? Does that person still perform all these job duties? Are there any new job duties that this person is doing? Is this person actually now working at a different location? Do we have the LCAs in place for those locations? For the H's, for the L1s, and the H's, do we have a copy of all of that person's current immigration documents? And the reason I say that is because, while the site inspector is walking around and what they're talking to individuals, they can ask for, various things from various people. In particular, they can ask the beneficiary for, their I-94, their visa, or their I-797 approval notices. Also, they can ask for their business cards, etc. So, think about things that if you were an FGNS site inspector, for example, would want to see just to verify that what's in the petition matches with what's reality. The business cards, the online bios, etc. If your beneficiary is out sick that day, that is one big trigger to get, a follow-up email asking for, a laundry list of documents that either you already gave or are not applicable, etc. So that's another, good reason to have a copy of the person's current documentation on hand in this non-public file. If you're asked a question by the site inspector that you don't know the answer to, don't guess. If they're saying, so this person's job duties include X, Y, and Z, and you say yes, but that's actually, maybe a trick question that was not in the petition, or the person had wrong information and, wasn't trying to trick you, but, got it wrong. Nonetheless, they write down that in their report. Perhaps someone at HQ sees the inconsistency, and, maybe throws a non-verified report at you, or a request for evidence, or notice of intent to deny, or notice of intent to revoke, etc. Be diligent in making sure that everything in your files for that H-1B petitioner and that H-1B beneficiary and L-1A beneficiary are in fact up to date and accurate. If you don't have copies of your petitions that were filed by your company for that individual on hand, get them. You should ask your corporate immigration counsel for a copy of them. You should have them on hand. Those documents are key, and the most important part. And in L1 context, the majority, if not the sole, controlling document. We'll get into the specific documents that would go into each of the L1 and H1 compliance files for this in the next few slides. I just want to say first that every employer is different, every situation is different. This list is for the compliance files in this regard are meant to help you prepare for the worst. It's not guaranteed that during the life cycle of any L1 or H1 that you will get a site visit for that person. But if you employ, more than one person, if you employ several H-1B employees, or any number of complications that you're not keeping and that cause you to not keep track of these compliance files, could set you up for an expensive and frustrating 2 business day period of trying to respond to this email that's asking a ridiculous amount of irrelevant questions. So, without further ado, well, actually, before I even get into the compliance file, I also just want to say this, that the H-1B public disclosure file, which we will discuss after the FDNS section, is, in our experience, has not been the direct target of the site inspections for FDNS. They're more interested in confirming that what is in the petition is what is reality. They can and they could, and I, in some instances, have seen them ask for public disclosure file information, but more often than not, the site inspector will be focusing on, the questions, the interviews, talking directly with those people, verifying that the actual place of business is a real one and matches what's said in the petition, and asking for, verification of things that were submitted with the petition. The public disclosure file is something that must be maintained separately, and in tandem with the public disclosure file, the non-public documents that must be kept according to the H-1B and LCA rules are in fact relevant for the FDNS. So the non-public documents, the documents that are not available for public inspection by anyone, if you ever have trouble remembering what goes into a public disclosure file versus a non-public file for an H-1B, consider this kind of just quick strategy. The public disclosure file, for all intents and purposes, doesn't have any personally identifying information in it for most H-1B employers. The exception there being those who are willful violators or another category that we're not going to discuss here. But for almost all H-1B employers, your public disclosure files don't have personally identifying information in it. It has things like LCA numbers and job titles and locations, but it doesn't identify that exact person by name. The non-public file, however, is exactly, the personally identifying information for that beneficiary, including the copy of the file, pay records, etc. So I just want to distinguish between the two on the H-1B side, between the public disclosure file and the non-public file. The non-public file, for all intents and purposes, is part of the compliance file for FDNS. Those are the documents that will be important on that side. So what about L-1 employers? The most important and key elements to have in your L-1 employer compliance file in the event that you get a post-adjudication site inspection by FDNS. Definitely have the company authorized individual have handy a complete copy. We provide them to our employer clients, bound with a cover on them, clearly identifying what it is with copies of everything that was filed. If there was an RFE, a request for evidence, and then a RFE response, that's included in this complete copy so that it's bound, it's all in one place, it has a clearly, identifiable table of contents or index of exhibits, and it includes all of this relevant information. Now, the list, the sub-list here, the bullet points below each of the headers, for example, having evidence of a qualifying corporate relationship of the entities, that was included in the petition. It's different for every petition. It's different for every company. It depends on the type of relationship between them. Why I include, an exhaustive list here is actually because this is what FDNS has identified as the items that they would like, or rather are normally or usually included in an L-1 petition. This came up because, for example, an employer was either unavailable or, the person wasn't there that day, so they received an email from the site inspector asking for all of these documents, and the employer was very confused. Why are we getting this? Why do we have to respond with all these items which are not applicable? We either, aren't this type of company, or we didn't include this in the L petition, but it was approved, so why are we being asked for it by FDNS? Hence the reason why you should have a compliance file on hand to avoid those type of emails with the 2 business day response. But nonetheless, this is the list of items that can be asked for because they're usually included. If you're there for a live site inspection and these things are asked, it's easy to explain to the site inspector, well, we actually, this is what's it. This here is a complete copy. The L is filed. The evidence that we submitted to prove our qualifying corporate relationship between our company and the company that employed the beneficiary abroad was, say, the annual report, that lists, Company A as a subsidiary of Company B. Or we submitted our tax returns, which, lists the foreign subsidiary as 100% owned by the U.S. company or something similar, right? Nonetheless, it appears that FDNS, in conjunction with USCIS, wants to more, perhaps streamline the L1 process. So in addition to thinking about making sure you know where and what evidence was submitted for the L1 petition to prove qualifying corporate relationship, also consider, more in the long-term strategy, regularly including the same type of evidence proving qualifying corporate relationship for all of your Ls if you have multiple of them on payroll. That way, you're not scrambling to flip between, copies of complete L1 individual petitions as filed with USCIS to see, oh, what did we do for this one? Oh, what did we submit for that one? Well, if you do the same evidence for all of them, you'll know, of course you should be sure, but it will be less hassle for you down the line. In addition, in the event that the site inspector wants to see something that you did not file with the underlying petition and it was still approved, it's in your best interest to supply it anyway, but it's easier to reason with one of these site inspectors live rather than after the fact via email within 2 business days. It just makes everything easier, more streamlined, and less headaches, less time, less expense down the line. For evidence of the ongoing business activities of the entities, some of these are crossovers with qualifying corporate relationship evidence. A solid L1 petition that was approved by USCIS already proved the qualifying corporate relationship, that they're, doing business and they have been open in the U.S. for more than a year, etc. All these things, I don't see as often USCIS in the L1 adjudication context asking for the lease agreement necessarily, especially if it's a company that's been around for a long time in the same location, multiple petitions approved, etc. But you might get a site inspector who asks for evidence that the company either owns or leases their business premise. That's something to be aware of. So if your company, if you can explain it and the site inspector is satisfied, great. But if they want it anyway, consider having those types of things on hand outside of the context of what was in the petition. So these LFDNS site inspections have been only going on since roughly June, but be aware for you, if you don't have these kinds of things in your L petitions already, to consider including them in that compliance file. Or, if you have multiple Ls, say, having them included where you keep those individual ones so that you can readily give them to the person when asked. Other things that are, typically or normally included in the L petition as filed, evidence of the beneficiary's qualifications and qualifying employment abroad, managerial or executive. This usually includes showing that they had that year, at least 1 year of employment abroad by the qualifying entity. That can be pay records, either 12 months of it, or the equivalent of the W-2 in the U.S. in that country, as issued by the entity abroad, the employment verification letter, which discusses their professional and or academic credentials and achievements, the resume CV of the applicant's beneficiary, their transcripts, degrees, certificates as appropriate. Often the L1 petition, one thing that's not listed here too is the personnel organization chart from the entity abroad. They usually like to see that, especially for the managerial or functional manager L1As. It's a good idea to have those in there and include them in your L1 petition from the get-go, so that if you're asked for something like that and you didn't include it in your individual L1A petition, you're not scrambling to contact, with time zone differences and everything, the beneficiary's manager abroad to try to get something like that. The beneficiary's immigration documents and maintenance of status documentation, this is, it brings up, a clarification point for, which L-1A petitions are being randomly selected for this. FDNS indicated last year that they were going to do and start the L-1 site visits for L-1A extensions. So this would obviously be for L-1A extension petitions rather than the initial one where this information would be included. Nonetheless, it's also a good idea once the person is here in the U.S. and working, either after going abroad, getting the visa, coming back, or upon approval, going to the embassy or consulate, getting the visa, entering the U.S., and starting to work, having their current visa, I-94, and passport page on hand. This is something that the person could also do. Whenever a site inspector is interviewing that person, the beneficiary, they would ask for, and they could ask for these things. If you also have a copy of them, though, that's helpful, especially if maybe the beneficiary is not there that day or the beneficiary doesn't have, their original passport on them, which, many people don't always have that document, in their bag or whatever. So just think about having these kinds of records on hand. It's good practice, usually whenever the individual enters the U.S. And they go through the I-9 process, maybe you get some of this but not all. Nonetheless, the Corporate Immigration Council usually asks for these things anyway for their records because they need to keep their databases current, etc. So, if you don't have these things readily available, you can check with your Immigration Council to see if they have them readily available. And of course, pay records for the person. If you did an extension, an L-1A extension for someone who had already been here for 3 years and now they're on their first of the two-year extensions, likely you included evidence of that person's maintenance status, which included evidence that they were in fact paid, their most recent pay records, or if it was done around, a change in the new year, perhaps their W-2 from last year or something similar. And then if it was an L-1A extension that included L-2 derivative family members, evidence in that petition as filed would include, the forms and documents for the family members, including showing that they are in fact related to them, their immigration documents at the time of filing, and any, certified translations as needed. All of that, everything I've talked about here, for the most part, is something that is likely in the L-1 petition as filed with USCIS. To the extent a site inspector asks for something that's not in there, they will follow up and ask for it if they decide that it's relevant. If it's that day and you can reason with them to show, this is what we submitted to prove qualifying corporate relationship and ongoing business activities. I'm sorry, Inspector, I don't have that on me right now, but if you prefer, that I provide it, I'd be happy to do so upon request. I'm sorry I don't have that information right now. I'd be happy to look into it and get back to you and provide it upon request. Those are the types of things that you can say to a site inspector and make them, or rather put it in their court as to whether or not they think that it's relevant. Moving on to the H-1B, like I said, the H-1B non-public file that must be kept in tandem with a public disclosure file pursuant to the LCA and H-1B regulations and rules. Of course, the first one is the copy of the H-1B petition as filed with USCIS with all supporting documentation. Lots of the key information in there is what the FDNS site inspectors are going to be looking for, as well as the payroll records. These, as opposed to the other items for H-1Bs in particular, must be kept for 3 years from the date of creation. Everything else is 1 year minimum from the date of termination under the LCA. Excuse me. So whenever you have a public disclosure file and an LCA, one of the rules there is that you provided, in order even to file, that upon certification you provide the foreign national with a signed certified LCA on or before the day they start working. So in the non-public file, you should keep confirmation that you did this. It can be a signed dated memo confirming the date and time or whatever that you gave the signed certified LCA to the person. It could be, a quick email to yourself, a reminder, something, just to make sure that you documented that. Documentation of any benefits provided, offered, accepted, etc. to the foreign national. You should also, consider having the list of benefits that you provide to everyone, if there's anything different in there. This is particular to that person, the foreign national, in H-1Bs. So, this would be, this could be, just a standard HR record, like this person elected to have employee medical plan A as opposed to B, but all employees are offered A and B. Because it's particular to that person, it's non-public. The statement of benefits that's in the public disclosure file is different, and I'll show you what I mean in a minute. And feel free, to ask questions throughout, by the way. At the very end, we'll go through. You can type in your questions, and then we'll go through them at the end and see if we can help you. And if we don't get to your specific question, you can always email us afterwards. And also, I already see a common question on this list is, yes, we will be providing these PowerPoint slides. They will also be available for download, and this is being recorded, and you will be able to watch it later should you need to. And finally, yes, as a quick answer, CLE credit is available for this. In California, we are an MCLE provider, which information is available upon request. So just shoot us an email. All right. So just jumping back in, if there's a change in corporate structure, which I will discuss in detail for the public disclosure file, the non-public file for the on the LCA side of things is a list of the H-1Bs that were transferred to the new entity, including their names as they match up to the LCA numbers, because the public disclosure file only has the numbers. I will skip the single employer test and willful violator information for now. And just a quick final note about H-1B fees. Site inspectors we've seen for FDNS have asked employers whether or not and to what extent, if so, the beneficiary paid or was reimbursed the employer for any of the costs associated with the H-1B. The rule is all costs and fees should be paid by the employer because they're business expenses. That's what the Department of Labor says. Now, there are specific exceptions that if it's not one of the employer absolute mandated costs, if the cost is paid by, or the employee reimburses the employer for the cost for these other types of fees, for example, like the premium processing fee. As long as that doesn't reduce their wage below the required wage, it would be okay. However, best practices is that the employer should pay all the costs and fees. The $500 fraud prevention fee and the Acquia training fee of either $750 or $1,500 must, no matter what, be paid by the employer. The employee may not pay those at all. The employee may not pay any legal fees associated with the LCA. Because of these kind of nuances about fees, costs, etc., that's why we say best business practices is to have the employer cover all the costs. If there are any specific questions about this, and we often get them, feel free to email us afterwards. But just know that absolutely no matter what, that Acquia fee and the fraud fee must be paid by the employer. Often, if the employee pays any of the other ones and it reduces them below that required wage, that is, a violation. So really, to protect yourself, your business, the employee from being determined to be out of status or anything like that, the employer should be covering all the costs and fees. The things that the site inspector would ask about in that regard are, in the interview. So, beneficiary, did your employer ask you to pay any portion of the legal fees for this? Or did the employer make you pay any of the fees? Who paid them? Do you have copies of the checks? Well, the copies of the checks likely would be included in the copy of the petition as filed. That's on record with the employer. So, if you don't have a complete copy of the petition as filed, like I said, ask your immigration counsel to give you that complete copy. Have them on hand. So, at the end of the FDNS site visits, be it an L or an H, there's verified and there's not verified, and then there's not verified and we suspect fraud. Verified, that's the vast majority of them. Of those 75,000 H-1B site visits that were completed since the program started, almost all, obviously not all, but almost all have been verified. If they're not verified, USCIS can request additional evidence and or initiate notice of intent to revoke, notice of intent to deny, etc. If they do suspect that fraud, it's very possible that they could, conduct additional inquiries. That includes but is not limited to investigations. They could, refer the case to ICE. They could also, maybe inform Wage and Hour or the Department of Justice about something, especially if it's an egregious, violation that comes up during the process. So therefore, it's really important to just know exactly what's in your petitions, making sure that those petitions are reflective of reality. If something changes, addressing that change, talk to your immigration counsel about whether or not it's a material change that requires an amendment, or if it's something that, can be dealt with a less formal administrative process, etc. But, that's in a nutshell the FDNS site visit program. I realize that I'm talking a lot and taking up a lot of time, but I want to make sure that we have time for questions at the end. So in that regard, I'm going to not spend as much time talking about the LCA attestations so that we can talk about the public disclosure file a little bit more. But in that regard, I think the most important LCA attestation that requires us, a little bit more in-depth discussion is what is the required wage, especially whenever, you're thinking about, well, who paid the fees on this? Did that reduce someone's actual wage below the required wage, or the wages paid below the required wage? What is the prevailing wage? All of these questions. I think that this is the one that, sparks the most debate also. Individuals, can disagree on, whether or not and to what extent someone's actual wage or prevailing wage is actually higher than the other. We'll start with actual wage and what it is. This is what the employer, actually pays or has paid or will pay people in the same or similar occupation. If you have 5 architects and they all make between $75,000 and $150,000 a year, and you have someone that you want to hire on an H-1B who is entry level, and you would look at the scale of what what you pay the other ones, their level of skill or expertise, their qualifications. Are you paying the other entry level person who's already on staff that's 75? If so, then yeah, that's the actual wage. So then you also have to look, though, at the prevailing wage. The prevailing wage, there's many different publication sources for this. The one that's most commonly used by employers and the one that we regularly go to, unless there's a private wage that the employer prefers, is the OFLC Online Data Center. This is a Department of Labor source of information about the different levels, wage rates ascribable to each level in a geographic location. So if you're, say, I'm just making this up because I don't have that, in front of me. But let's say in Seattle, an architect, entry-level architect, level 1, the OFLC Online Data Center says that the level 1 wage is $68,000 a year. So you're like, oh, so I can pay my H-1B worker $68,000 a year instead of the $75,000? No. The reason being the required wage, and I will go back to it in a minute, but here's the required wage. You actually have to pay the higher of the two. So if your actual wage rate is $75,000, the prevailing wage rate is $68,000, you have to pay $75,000. That is the required wage. On the flip side, if the prevailing wage rate in New York for an architect is $101,000, then in your actual wage rate, though, for other entry levels that you're paying, say for U.S. workers, that is $75,000. No, you don't get to take advantage of your actual wage rate being lower than prevailing wage. You actually have to pay the required wage rate of $101 because the prevailing wage rate 101 is higher than the actual wage. So it's the higher of the two. The required wage rate aside, the wage itself has to be paid to the employee, free and clear when due. When due is usually, or not usually, it is as you pay other individuals. So, if you pay everyone in the company, in particular, if you pay those architects, every 2 weeks, then you would pay the required wage every 2 weeks to the H-1B worker. You have to do this. You have to report all earnings. Unpaid bonuses, you can credit those towards satisfaction of the required wage obligation if the payment is assured, but if it's not a set in stone, contractual, for example, bonus, or, if it's performance-based and it's uncertain, you cannot use that to meet the satisfaction of the required wage obligation. Only authorized deductions may reduce the wage rate. So, whenever you're considering gross and net, it is the gross wage rate that you are considering. Other considerations, let's just make sure that we clarify here that H-1B employers who are institutions of higher education or affiliated programs or research organizations affiliated with those nonprofits, affiliated with those schools, actually use a different wage system on the OFLC Online Data Center. So, for example, those employees on the OFLC Online Data Center, there's a drop-down, all industry database or Acquia specific. So just keep that in mind. Moving on, I'm going to skip this section for now in the interest of time, but you can refer to the PowerPoint presentation later as you go or ask questions. So the public disclosure file, which for those who may not be familiar with the H-1B LCA program, before you can file the LCA with the Department of Labor, you must certify that all those attestations that were listed there. And one of them is that you will, make sure that you keep this public disclosure file readily available for inspection by anyone in the public. It can be the H-1B beneficiary. It can be another employee. It could also be FD&S if they decided to ask for it, even though we already mentioned that that's not their primary purpose. But, the Wage and Hour Division or the Department of Justice, they may want to see it. Anyone who wants to see it must be able to see it. So the public disclosure file is kept separate and apart from, the person's personnel file, their I-9 file, their non-public file. This is something that, should be the person who's in charge of the FD&S program should also be in charge of these. It doesn't necessarily have to be the same person, but for streamlined purposes, it makes sense. The public disclosure file is particular to positions. So, it's if you have 5 H-1B workers, then you would have 5 public disclosure files. Each public disclosure file, say for a position, let's say you have to amend one of these positions because that person is going to work at a new site, that public disclosure file, you should be able to point to that, oh, there are multiple LCAs now that we're maintaining for this position. Or maybe they have multiple work locations that are in excess of the number that are available on the LCA. Just keep in mind the mechanics, or excuse me, the makeup of the public disclosure file. We provide our clients with, a sample public disclosure file that includes a checklist of the items that need to go in, and then sample documents that can be used to meet the specific requirements on this laundry list of items that go in here. First of all, once an LCA is certified by the Department of Labor, you print 2 of the LCAs that are certified. You sign and date both. You give 1 to the foreign national, and then you keep the memo stating, that you gave it to them in the non-public file. But then you put the other signed original in the public disclosure file. That's the most important. Whenever you have the notices that you put up and you take down, that's your evidence of satisfying the notice requirements. 2 conspicuous locations in each work site up for 10 consecutive business days. Note the dates and locations that they were up, initial, sign, put into the public disclosure file. The prevailing wage info and source documentation. I'll show you an example of what that looks like in a minute. Summary of benefits for all employees in the same or similar position. We talked about the specific benefits offered and either accepted or declined by that individual in the non-public file. Well, here's the public disclosure file, kind of summary version of that. If there's been a change in corporate structure that has in any way impacted your LCAs, you keep the declaration of the change in corporate structure. Say that the successor entity has assumed all liabilities and et cetera, of the certain certified and active LCAs by the predecessor entity. The list of the LCAs that were affected by that change. That document then doesn't list everyone's names on it. It just has the list of the LCAs. But when referenced against the non-public file, which actually has that list of the people's names as it relates to the LCA numbers, it's key. So whenever you have those changes in corporate structure for H's, both the public disclosure file and the non-public file / FDNS compliance file are updated simultaneously. Here are what the samples look like for, just in general. The actual wage memo, this lists, this is how an example of if an HR person, sets the recommendations with the personnel director, we determine base pay in this way. Based on the application of the criteria above, we've determined that, the salary range or rate, depending for the position, for employee number I-200, and note that that I-200 refers to the LCA number for that position, not the person's name, to be whatever per year. This is a sample of what one could be like if filled out and is accurate according to what the company does. To document the fringe benefits offered to individuals in the same or similar position, this is also what it would be like. You want to make sure that you show this is what's offered to the H-1B non-immigrant associated with the LCA. This is what we offer everyone. If it's different, talk about it. It's not supposed to be different. So, that's one of the attestations for the LCA program. For prevailing wage source information, the independent authoritative source is what the OFLC Online Data Center prevailing wage rates satisfy, so just keep that in mind. And then, kind of closing this out and wrapping up the H-1B LCA attestation section. If there are any changes during employment that affect an H-1B worker, if it's minor, if it does not really, change the terms and conditions of employment, then, no new amended petition is necessary. If the employee is changing location, work site location, and it's not one that you have a certified LCA for, you need to have a certified LCA for it if the person's going to be working there for a longer period of time than a short-term placement. A short-term placement, by the way, is either a 30 or 60-day, depending on where the person's home site is and exactly where it is. If you have a question about short-term placements, please email us. It is a very specific and nuanced designation. But the most important thing here is if the person's wage, say, is going to decrease. Let's say they got a decrease in wage or even a demotion or a change in positions. Even a promotion to a new position, if that new position doesn't qualify as a specialty occupation anymore, that's a material change that requires not just a new LCA but a new H-1B petition. And lastly, for an H-1B employee who is terminated, employers are required to pay and offer to provide them, rather, the return transportation costs. So that has been determined to be a one-way coach airfare ticket for them back to their last country of residence. There's no benching for H-1B employees. If they do request unpaid leave, that is permitted, but it has to be at the request of the employee. It has to be, approved by the employer. H-1B employees are entitled to Family and Medical Leave Act leave, just like regular employees. Whenever there is an H-1B termination, employers are required to notify USCIS immediately. So, that also means that as soon as that you withdraw the petition or notify them of the termination, USCIS, the H-1B worker, if they don't have anything else, if they don't have another H-1B employer or they don't have some other underlying status, there's no grace period at the end of an H-1B. They will be immediately then, last day of employment is last day of status. So some H-1B employers offer their employees, maybe, we're giving you a week notice that that's going to be your last day, just to allow the H-1B employee, the ability to make arrangements to either, maybe change status or at least close up their affairs if necessary. But most importantly, until that LCA is withdrawn, until you notify USCIS that the person is no longer there and withdraw the LCA, the employer is liable for back wages and required to pay that required wage up until the point when the LCA is actually withdrawn. I'm going to skip over the specifics of the H3 and H-1B1 program for now and the specific instances of special considerations for dependent employers and willful violators. This I already talked about with corporate restructuring. And without further ado, I'm going to turn it over to Jerry, who will now discuss the third and final portion about PERM.
Okay, let's start with the enforcement and PERM. Basically, the points that we're going to discuss is what is PERM and what are the employer's obligations and how does the government enforcement of PERM obligations work. PERM, surprisingly, it's not the unfortunate hairstyle very popular in the 80s. It actually refers to a program, Electronic Review and Management. It's a highly regulated program, which the idea behind it is that an employer is seeking authorization from the Department of Labor to allow them to employ a foreign national on a permanent basis. And in order to do that, the employer must demonstrate that they have recruited for the position. And as you can see from the slide, I'm not sure if you see the slides the way I do because they're not moving on my screen. But I'm moving towards discussing the first stage of the PERM process. So PERM, oh, there you go, they start moving, sorry. So PERM, the government institution that is involved in the PERM process is primarily the Department of Labor. PERM is also referred as the first stage of obtaining an immigrant visa, which is based on unemployment with a U.S. worker. Generally, and you will see later on in this discussion, we will distinguish the 3 steps in obtaining a green card through a PERM. I'm moving to the next slide. The PERM, the idea is that the employer has to conduct a good faith test of the labor market. And in order to do so, they have to complete various mandatory requirements even before a PERM application is submitted with the Department of Labor. The idea of the test of the workforce market is to show that there are not any able, willing, and available American workers who are able or are willing to take on the position and who are also conforming with the minimum qualification for the job. American workers are considered any U.S. citizen as well as permanent residents in the United States. The qualifications of the applicants who apply for the job are generally set in the beginning of the process, where the employer sets the position that they want to sponsor for a national, that they have a need to fill this permanent position. And they set up not only the duties, but they also establish what are the minimum qualifications, what skills this employee must have before joining the company that are unique and necessary to perform the job duties. And by testing the labor market, the employer informs the labor market of all U.S. workers about the position that is available, the qualifications that are required, and how this employee can apply for the job. By collecting resumes, the employer will later on establish and document to the Department of Labor whether or not these applicants have qualified for the job. What's important to remember here is that the PERM application is employer, employee, position, and location specific. So with advertisement for the job as part of the recruitment process, the employer must ensure that the position, the advertisement also indicates the metropolitan area where the position will be available on a permanent basis. As I mentioned before, there are 3 steps in the process of obtaining a green card through PERM. The first and the most time-consuming is the test of labor market, which is the PERM application, and the government agency which is involved in this process is the Department of Labor. Mostly the documentation, the filing and submission of this application is done online. However, with the possibility of an audit, the employer is also required to have an audit file where they keep all of this documentation. And we will go in a little bit more details later on in this discussion. The second step is obtaining an immigrant visa petition, which is the filing Form I-140 with the USCIS. This is a different government agency, and this step can be accomplished as soon as the PERM Labor Certification is certified by the Department of Labor. So Once this is completed and the employer has filed a petition which was adjudicated favorably by the Immigration Service, then the employee can move to the final step, which is the adjustment of status. As probably many of you know, there is an option to file step 2 and step 3 concurrently, depending on the priority date. But this really depends on what is priority date for a specific position and whether or not they are current. In step 3, we also have to recognize that employees do have an opportunity not only to adjust their status in the United States, but in some instances they may want to prefer to do consular processing, which will involve obtaining a green card by applying for this at U.S. consulate. And there is a different government agency involved, which is the Department of State. What's important for the PERM process as far as the employer is obligated to conduct a good faith recruitment and to be truthful in all of its attestation, as well as the employer is required to keep record of all steps which were taken towards the recruitment and all these mandatory requirements that they have to complete before the PERM application is filed. And as I mentioned, although it's filed online, the employer, it is crucial to keep very detailed record of these documents, because the Department of Labor has established a major focus of all enforcement actions related to the PERM by creating the so-called management challenges facing the Department of Labor, which are the top 11 in the process. What it does is, since the PERM process is filed online, the Department of Labor can easily monitor the amount of PERM application filed by a specific employer and can easily find red flags or distinguish some questionable practices. Therefore, it is recommended that the employer takes the recruitment step very seriously. And what exactly is the recruitment? The recruitment is advertisement for the position. Basically, before a PERM application is filed, this position is considered by the Department of Labor as an open to all of U.S. workers, meaning that employer will place an advertisement and recruit for the position. It's very strictly regulated area where the employer has to not only comply with its regular recruitment practices, but it also has to follow the recruitment steps and venues which were suggested by the Department of Labor. Most importantly, the recruitment requires that the employer has to place a job order with a state workforce agency for 30 days, as well as conduct newspaper advertisements on 2 consecutive Sundays. There should be a notice of filing, which is actually extremely important as it has to be placed at the place of employment. And it's one of these documents where the employer has to disclose the offered salary. Another important point when actually advertising for the position is the employer must ensure that all of the resumes, all forms of application for the position are collected, organized, and reviewed very carefully. It is crucial that the employer, should the employer communicate with any of these applicants, it is crucial that the employer document any communication, and this could be done by emails, and if for some reason employer communicate with potential applicant, I would recommend that always send a follow-up email or make a note in the file, and in good faith record this conversation as a memo of what was said, just to establish that the employer has made the effort. Another way of, also another important point with establishing a good faith effort for the employer with the recruitment process is the payment of the PERM costs, including legal fees. They have to be paid by the employer, and this is a very important requirement for the PERM application, as some of employers may not clearly give the attention of this requirement, as well as look into it as, oh well, maybe we can get payment from the employer, a compensation. The specific regulation for this requirement says that an employer may not seek or receive payment of any kind for any activity related to obtaining permanent labor certification. And by payment, the regulations specify that payment is included but not limited to any monetary payments, deduction from wages or benefits, kickbacks, bribes, goods, services, and any other in-kind payments. So everything related to the PERM process, the advertisement, any expert opinion letter to establish business necessity, this must be paid by the employer. And there should not be a reimbursement agreement between employer and employee, where the employee agrees to reimburse the employer about the sum of the attorney fees. So this is very strictly regulated, and I think it's something to look into when establishing a good faith practices and meeting the requirements for obligation. Another point with the PERM process is that obligation, as far as the position that is offered for the PERM, it doesn't end with the adjudication of the PERM process, the first step. It extends and continues until the adjustment of status is completed. What it means is, once the Department of Labor has certified a PERM application for a specific position with specific duties and specific location, employers must ensure that this position is available at the same location with the same duties for the foreign national until and even after the foreign national receives their adjustment of status. Therefore, if there are any changes in the job duties position for the PERM position for the foreign national, it is a good practice that before these changes are enforced, you would want to check with an immigration professional and make sure whether or not this will require change in the PERM or the immigrant visa process for the foreign national. Generally speaking, if it's a natural progression in the job duties and there is no material change like a standard promotion or career trajectories, this will not affect the PERM application, and it is a very generic like continuance on one's position. However, if the job is relocated to a different state, or if the company, the employer is no longer in existence. This brings a lot of questions that needs to be discussed before any action is taken, as they could affect the foreign national ability to obtain a green card. And it also depends on when this change should occur. So it is a common practice to make a note and just make sure that before any action is taken, this is discussed with the immigration representative or specialist with the employer. The next slide we will discuss is the retention of documents. As I mentioned before, all of the PERM applications are submitted online. However, the documentation regarding all recruitment steps that were taken by the employer must be retained for at least 5 years of the date of filing. It is an obligation for the employer, and generally an attorney who has done this, has assisted an employer in the submission of a PERM application is likely to keep this original in the employee's file. Employees are expected to have assembled and also to have at hand all documentation necessary to support application before they are submitted. It is a good practice to have this and organize it before you submit a PERM application. And there is quite a bit of discussion in the immigration community whether we should give electronic or physical retention of this record. Generally speaking, electronic copy should be acceptable. However, in case of an audit, the Department of Labor may require some original documents, for example, a notice of filing or a recruitment result report. So our usual practice is to keep these originals for 5 years with the attorney file, and also to provide the employer with electronic version of this document in case it's requested as a public disclosure file by the Department of Labor. Next slide is what documentation is generally required to include in the so-called audit file. Most importantly, you do want to keep the prevailing wage determination document, because it sets it's one of the requirements for the PERM process. It's important as far as it says the minimum wage that the Department of Labor has assigned for this position. Absolutely, you want to keep documentation of all advertisements that have been taken place for the recruitment activities. Generally, you would want to have printouts of the job order the first, the last day, and it is a good practice to have a printout maybe 2 weeks within the job order. So just make sure that all the dates match, and you are able to provide documentation that an advertisement or a recruitment venue had taken place. And a notice of posting, incredibly important, as well as notice to union, depending on whether or not the position is a union position or not. You do need to have the original postings, generally speaking. Should the position require business necessity, it is a good practice that these documents are retained in the audit file, and they are set before the filing of the PERM application, and usually by evidence of business necessity you can include a letter from the employer or the manager describing the position and why these requirements are necessary for conducting of this business. You might also want to do some printouts from advertisement for similar industry within the business industry, just to show that this is a common practice within this business field. Absolutely, the recruitment reports, as I mentioned before, you do want to have a detailed description of what recruitment steps have taken, what the results of these are, and generally I would like to have an original recruitment report signed by the employer prior to filing of the case. You also want to have the evidence of all attempts to contact applicants that I discussed earlier. It is crucial to have this because if the case gets audited, you do want to demonstrate that the employer did review all of these resumes. There were notes, and if for some reason it wasn't clear by the resume whether or not the applicant meets the requirements set for the position, you do want to establish a good faith by contacting, communicating with the employee and making sure of how the determination for rejection was made. This documentation, the audit file is crucial because if the case gets audited, you have to provide these documents, and having done this upfront properly and organize it, it will be very easy to respond to the Department of Labor requests for an audit, and it will make the process much smoother and easy to comply with these requirements. As I said, the PERM is a process that is mainly done online, and in order to ensure that employers do follow the recruitment requirements, the Department of Labor is focused on the following methods of enforcement. They're looking into fraud and willful misrepresentation, as well as they are looking into the integrity of the PERM program. PERM is a process that requires a lot of data, a lot of information, and there is a room for honest error. However, you do want to be very careful because you want to be able to explain this error and also to demonstrate that you do have, the employer has conducted a good faith effort. If an error occurs, the way of regulating is the Department of Labor may go through a denial of the PERM application or may ask for audit where you can explain, and if the audit explanation is still not enough to satisfy the Department of Labor requirements, they may ask for supervised recruitment, which usually is a way more strictly regulated process where the Department of Labor provides deadlines and approves the advertisement, and it's a way for the Department of Labor to look closely at some PERM application which will file, and they probably have brought a red flag in the practice of this particular case or for a particular company. So in these enforcement tools, we can easily recognize the soft enforcement tools, which are the denial, the audit, and supervised recruitment. And the most serious hard enforcement tool, which is looking into investigation, revocation, and even invalidation, as well as criminal indictment for the employer, and for the attorneys it could even lead to disbarment. When conducting a PERM recruitment process and just going through the filing of a PERM certification, it is extremely important to make sure that you do comply with all of the regulations and avoid any violation, because this is a very strictly regulated area, and enforcement could take to a serious end. So the soft enforcement technique generally denials could be done because the Department of Labor would consider that the PERM application, the employer has failed to meet the requirement and to show that there are no otherwise qualified workers. A way to work with a denial is an employer can file a request for reconciliation, or as well as it can file go through a bulk appeal process where we have a judicial review of the denial. Audits are the most common form of enforcement, and in a way they do tend to be like the equivalent of request for evidence that we see in some instances coming from the USCIS. Most employers could take the audit as something incredibly scary, and audit is a serious matter, but the way to look at it is that at least 30% of all PERM applications are audited. Some of them are audited because of the red flags that were recognized by the electronic system, but most of these audits are random audits where the Department of Labor wants to ensure that a recruitment has taken place. So as long as you have completed the audit file, you have everything, audit should not be should not be a concern. It's just a way of enforcement for the Department of Labor. Supervised recruitment, however, is a serious way for the Department of Labor to look into a PERM application that was filed by an employer, and in this case the department, usually you will see that a Department of Labor will lead to supervised recruitment after they have received response to an audit and there's still red flags. So by the supervised recruitment, the Department of Labor will strictly regulate and advise the employer where to advertise, what advertisement, and most importantly, with the supervised recruitment, all of the resumes will be sent directly to the Department of Labor and subsequently forwarded to the employer. As I said, these are all soft enforcement techniques, and if the employer has complied with the regulatory requirements, there should not be later a problem for filing new cases. The hard enforcement techniques is a case where the Department of Labor will reject the proposition that it would accept a certain level of unavoidable fraud. With the Fraud Detection and Prevention Unit, which was established in 2008, employees do use a data minimum techniques to identify and investigate appropriate violation. What it means is we're living in an era with internet and digital media and social media. So this makes it much more easier for the Department of Labor monitor whether a position does exist. So an officer of the Department of Labor will definitely have an access to social media and can review easily information on professional websites like LinkedIn, even Facebook. Sometimes they can check whether or not an employer actually holds this position. And high-profile companies are actually subject to stricter regulations, as they have to comply with a lot of SEC requirements, and they also have to provide a lot of public documentation. Strikes are also incredibly important, as you know, when filing a PERM application, you do have to show whether or not there have been layoffs and any disturbances with the employment. Sometimes employee who has left the company or for some reason are upset with the employer. Nowadays they do have a lot of opportunities to report or contact the Department of Labor through social media, online, and this also brings a scrutiny by the Department of Labor, although it is not a very likely process, but it is something that you need to be aware, and it's another way of making sure that you follow the regulation and keep a very updated audit file. So basically, investigations, so far they haven't been that common, but what the Department of Labor will learn, they look into patterns of misrepresentation or possible fraud. And by having done everything online, it's easier for them to determine whether, let's say, a specific attorney files a lot of red flag PERM application or a specific company. So they will see if there is a flag for that and look into it closer, and they can take steps to revoke an approved labor certification. So should the Department of Labor determine that although a PERM application has been certified, there is a reason that this certification was not justified, it is possible for the Department of Labor to revoke an approved labor certification. What this will lead to is that the Department of Labor will notify the USCIS as well as the Department of State, and this will lead to negative effect on the immigrant visa and even adjustment of status or green card application to the employee. Same applies with the USCIS. If they're reviewing a case and they notice that the Department of Labor has invalidated a labor certification, then both these government agencies do communicate, and each one of them will notify each other. So the way of communicating is much more easier, and it affects the regulation of this process. I mean, because we've been talking for quite some time, I will just briefly go through the CART Form 741, which is the suspension, where the Department of Labor can learn about employee, attorney, or agent who is under investigation. So in this case, the Department of Labor will look into all of the applications that we're filing. They may look into different triggers for this suspension, and they may suspend actually the filing of a PERM application for a period of time until they clarify whether there is a reason for fraudulent activities. Another form of the hard enforcement is the criminal indictment. This is a very serious criminal federal crime which actually could lead to imprisonment, and it could be also punishment by fine. It does apply to persons as well as entity that aid and abet or even counsel others to commit the abuse the system. And also it could be indicted not only by a federal crime, but as well as the U.S. immigration document fraud and perjury provisions. For some recent examples, you can look into an immigration paralegal in Connecticut who has faced multiple years in jail as well as fine for falsifying evidence, which also include employment experience letters. So, I mean, the Department of Labor as well as the federal government do take these matters very seriously, and as you can see from the slide, they are precautious for fraudulent activities. And another form of punishment is the debarment, which considering the attorneys and their unique position with the PERM process, any fraudulent activity or guiding through in a way they could lead to their disbarment, usually for several years, but it is not something that should be taken lightly. This is pretty much the regulatory requirements for the PERM process. And should you guys have any questions, please feel free to contact our office, email your questions to us. And with that said, I will let JJ take over.